Hello, everyone. Thank you so much for joining our webinar titled Post-Termination in Construction Projects, Claim Disputes, and the Role of Expert Evidence. This webinar is being moderated by Mr. Dhananjay. He will now be taking it over. Just a bit of hygiene rules before we start. This webinar recording will be available after the webinar is over. Please feel free to use the Q&A box to put in any questions that you may have. Thank you so much. Dhananjay, over to you.
Thank you, Chaitali. So usually now terminations are often seen as the end of the project, but in reality, as you know, it marks the beginning of most complex phase of claims, disputes, and expert analysis. And today's webinar, we are going to discuss this aspect, especially in Middle East region and in the international level or on an overall basis. We have a distinguished panelist today with us. Let me start the introduction of our distinguished panelists today. First of all, I welcome you all, sir, here. We start with Mr. Basim Alim. He is the founder of Alim Law Firm. He brings with him more than 30 years of experience in legal practice as well as international arbitration. He holds Juris Doctor from American University and also an LLM from Harvard School. He is certified arbitrator in Saudi Arabia. He has served as a chairman and member of arbitration panels in numerous high-profile cases, as well as he currently chairs as a board of United International Transportation Company, also known as Saudi Budget. He is an active member of leading international legal association and is widely recognized for his expertise in complex dispute resolution and legal advisory. Welcome, sir. We have another panelist, Dr. Ahmad Basrawi. He is partner at Al Tamimi and Company based in Saudi Arabia office. He has also served as a lecturer and litigation and commercial law expert in University of Jeddah. He has more than 20 years of legal experience with him. He has extensive experience in appearing before courts and arbitration tribunal in Saudi Arabia across a wide range of areas, including construction, commercial disputes, administrative level law, as well as shipping, insurance, banking, intellectual property, quite a very wide range of sectors he has worked on. Welcome on board, sir. In fact, he has also successfully negotiated. So he's apart from arbitration, his main folio has been a negotiation, a kind of role where he has settled some very high complex dispute in the arbitration. We also have with us Brendan Mock, partner at Clyde & Co. at the Saudi Arabia office. He has over 10 years of experience handling high value and complex engineering dispute, both in litigation as well as arbitration. Brendan has a particular focus on international arbitration, where he regularly advises clients in high-stake bid the company disputes. That's interesting. He is known for helping clients navigate challenging situations and achieve the best possible outcome. Once again, I welcome you all, and I think we should start with our session. It's going to be a session with in a question and answer form, where I'll be asking a question to our distinguished panelists, and then we can take it to a kind of interactive session. So let me start the discussion with Mr. Basim on the panel. How you would like to see, like nowadays, do you see like the other termination events in EPC projects are increasingly being used as a strategy to dispute, or they still primarily drives by the project execution failures? Mr. Basim, please.
Thank you. When we look at this question, we have to just step back for a moment, if you don't mind, and look at the full legal culture in Saudi Arabia. Unfortunately, there are many intertwining factors that play into the final decision of termination. Some of these factors are the delay in government payments, or government deciding to terminate the main contractor, or the main contractor having financial difficulties. And unfortunately, when we have a main contractor and the owner, or what is known as the employer, the ultimate employer, especially if that is the government, we are faced with the problematic issue of actually drafting the contract in itself. Contracts are not intertwined together. The subcontractor's contract is not related to the initial main contract. So whatever default by the main contractor is always given to the subcontractor as another default. And therefore, we see on many occasions that the main contractor terminates, or the owner / employer terminates, based upon financial difficulties, based upon delays. Some of these delays could be because of the actual negligence or dragging the foot of the contractor, or they could be because of parameter situations, especially in the holy cities of Mecca and Medina, where there's huge amount of construction, and it's intertwined with what we call Hajj and Umrah and other projects. For instance, Riyadh, some of the construction projects are intertwined with the what we knew in the past as the Riyadh Metro. So yes, it's becoming more of a strategy than a simple legal action period. Yeah.
Thank you for a detailed explanation. Any quick take on this, Brendan? Is it a strategy or still rooted in a primarily in a failure of the project?
Thank you, first of all, Dhananjay and Mason for hosting us. I think it can be both. I think in my experience, though, it's still primarily used when there's an underperforming party and the counterparty wants to improve the performance of that underperforming party. There are other options, less drastic options than termination. For example, a party might threaten financial claims under the contract, but that often doesn't improve the performance of, say, an underperforming contractor. It might also be that a developer can't novate the contractor to another party or replace that contractor, and also can't omit works from that contractor to a replacement contractor or to carry out the works itself. So in my experience, termination is a really useful tool, not always for strategy, but more for actual project execution failures and a way of resolving that. Just a couple of points as well to add. In many jurisdictions, including in Saudi Arabia where I work, the overlaying statutory regime prohibits or in fact prevents parties from acting in bad faith. So you have articles under the Civil Transactions Law saying parties must act in good faith. Parties also can't abuse their rights. So one has to be very careful about making threats of termination without valid grounds simply as a negotiating tactic. So I would never advise that. I think if they have a valid ground to terminate, they might not want to carry through with that and might want to raise that in discussions. But I wouldn't advise bringing that up as a negotiation tool without any proper ground in which to do so.
That's very interesting. I mean, we have seen often like it is being used more like a tactic to do the negotiation, but definitely there should be a ground there. Mr. Ahmed, would like to add on anything to it, Dr. Ahmed?
Yeah, I just thank you very much and good afternoon to all our attendants joining today. And I just would like to emphasize on what my colleagues was saying about the using the termination as a strategic tools and also as a legal remedy. But we need to understand one point, that terminations in accordance to the civil law in Saudi Arabia, it's not by one of the parties. It's sometimes or most of the cases it needs a tribunal orders or a court judgment to terminate the contract, because it's in some cases I have seen is not automatically terminated by the parties, even if sometimes they can terminate it without needs for the court order or something. But termination always is a ground for a dispute, and there is sometimes they use it as a threat to the other party to complete the project or to finalize the project or to waive that there is any kind of liquidation for the bank guarantee from the contractor side. For that reason, or for this huge consequences for that termination, they might use it as a technique, as a strategy decisions to enforce the other party to fulfill their obligations, or they want to sometimes escape, or they want to cut the losses incurred on the contractors. He want to cut the losses, and also it's sometimes we see now the many employers getting educated legally about not seeking terminations to step in right, or to ask for fulfilling or to complete the contract under the employer's expenses. We saw those kind of cases. That's why I think in most of the cases, terminations is a commercial strategy. Uh, in many occasions, I have seen that recently.
Thank you for those inputs. So let's start with you, sir, once again. This section we will be discussing more on the termination legal framework and practical reality of termination. So I will again start with Dr. Ahmad. So what are the key legal consideration immediately following the termination in Saudi Arabia as well as in overall in Middle East region, and how strictly this compliance in termination process matters?
Uh, Yep, it's very interesting questions and good questions, and it's very wide questions. As you know, that there's a lot of legal issues in that terminations, and let's start when they are looking for the ground for the terminations, or what the reason for the terminations. Always we are talking now about breach of the other one of the parties of the contract. They need to send the notices, and that notices trigger all the risk associated in the projects from the contractor side or the employer side. The notices is very important, and from the contractual sides, and many times the notices or for rectify or fix problem or to fulfill another obligation. If you didn't fulfill that obligation within a period of time, then the contract will be terminated, and that's why it needs to be well drafted, because in Saudi Arabia, in accordance to the civil law transactions, they they emphasize on the notices, and they emphasize on the giving a period, and also the law expressly said the terminations couldn't be for a minor contractual issues. It must be serious breach, is not a normal breach, as my colleague said, Brendan, that they must act in a good faith. Always they are trying to mitigate the losses. The counterparty or the injured party he has an obligation to mitigate the losses, and this is the one side. And the other side, and this very important side, about the location and about the side of the projects. If the termination is happening, what we will do with the assets, what we will do with the bank guarantee, what we will do with the quantum survey. For this is your guys is you play an important role in that one. They don't need to be very emotional about that decisions. They need to be very practical, and from the law side, they need to take an actions from the court procedures or a tribunal procedures to quantify the status of the proof, the status of the projects, and the other side. I don't I think it's a very big questions, and this is what I came to my mind for now.
Thank you so much. I know the spectrum of the question is very large, but then thank you for keeping it a bit concise, but very, very helpful information with us. So I'll come to Basim, Mr. Basim. So in practice, like what are the most common procedural or documentation gap the parties usually have to follow the termination in EPC contract or large value projects? What's your experience?
In my experience, first of all, I'd like to concur what Dr. Ahmed said. But in my experience, and I think distinguished panelists will agree, is that especially in Saudi Arabia, documentation of partial delays or partial problematic issues between the owner/employer and the contractor or subcontractors, these partial matters are rarely documented. And I myself, as an arbitrator, I'm faced at the end of the day when I'm in the arbitration panel, I'm faced with a simple one-page notice for the delay, and I look for the past. Were there any notices, any warnings, any what we call in the genre as building a case for the subsequent delays and the consequent delays and non-remedy? It doesn't exist, unfortunately, because of the pace of the projects. And sometimes the relationship between the contractor and subcontractor, or the relationship between the contractor and the employer, these two matters really heavily affect the situation. The other thing that is also important is that the affected or aggrieved party usually does not have the possibility of entering the site to quantify their work that has been done until this moment of termination. On the other hand, they don't have the expertise supporting them to give legal and engineering construction opinion about what happened, the reasons for the delays. They simply are faced with the termination letter, and they go immediately to either mediation, which is rarely fruitful, and they jump immediately then afterwards to arbitration. Documentation, regardless of how good or bad the relationship is between both parties. And these documentations should be, I would say, in good faith, and should be very technical rather than narrative. Unfortunately, that doesn't take place even between the best of companies, unfortunately.
Documentation. Very well emphasized there. So, Brendan, like, what is your experience? How you compare this approach typically seen? Like, what are like international practices in arbitration now? We got a specialized view on Saudi Arabian market and Middle East in particular. But like at an international level, how you look at it?
Yeah, so I think it's very similar to what Dr. Ahmed and Dr. Bassam have just outlined. I mean, of course, how the arbitration works and the substantive law of the arbitration will depend on the party's applicable law chosen in the contract. I think a lot of times in a lot of legal systems, for instance, Saudi Arabia, Australia, where I'm from, the contract or the law of the contract, the law between the parties, is paramount. So that means that tribunal members, just like judges in a court, will primarily pay attention to the termination regime set out in the contract, which will often define termination events, which give a valid right to terminate, and also the financial consequences of termination as well, which can be very significant. So I think tribunals, just like courts, would have close regard to the contract. There's then that overlay I talked about before of the mandatory laws within the country of the general law. And quite often, for instance, Saudi Arabia, as we've heard, termination is covered in the civil transactions law. It's quite broadly described, I'd say, quite a high level. There's basically three ways of termination, or options for termination: termination by agreement, termination for convenience, and termination for breach or default, which is not dissimilar to many other jurisdictions around the world, and indeed what parties would often write out in their contracts as well. So when there's that consistency, I think the arbitrators can pay close attention to the contract and not be too worried about the mandatory background law. But where there are conflicts, then some adjustments might be needed between the parties. And the last thing I'll say about arbitration is that arbitrators, and going back to documents point, arbitrators also love documentary evidence. So as has been mentioned, notices are very important, and notice requirements in the contract are demonstrated to have been complied with. There's demonstrable evidence of material breaches. So at this point, you need to bring in a delay expert. For instance, if the argument is that the contractor was slow in its works and was falling behind, you'd need a delay expert to prove that. And the tribunal would need to be convinced because of the significant consequences of termination. So quite similar, I'd say, but again, very, very document heavy.
Thank you for that insight. So let's come to the consequence part of that. So termination has been, say, let's let it be a kind of trigger, but it has got huge consequences. So let's come to the claims part of that, to be specific. I'll again start with Basim, like what type of claims are most commonly contested in post-termination dispute? Cost to complete prolongation, loss of profit. What has been your experience so far?
Well, the biggest claim of all is usually the cost of completion. That's a very complex claim. It looks very simple on the face of it, but because many of the matters in the project are intermingled, they're linked together, especially when there are additional orders that would stop the terminated contractor from doing something until the other part is finished. It's part of the project management, by the way. These matters are extremely delicate and extremely difficult to quantify, and it needs people like you to help in that regards, and experts like you. So the cost of completion is very important. This also pours over to what we usually heavily emphasize, which is the delays in progress. And the reasons for the delays in progress, was it because of the project? Was it because of the drawings, the administrative work, government permissions, semi-force majeure in places like Riyadh or Mecca or Medina, where there are some seasonal aspects for Hajj or Umrah, or let's say in Riyadh when there is the huge mega project of the metro, which has thankfully finished. These issues are also extremely important. Now, there's also the dispute between the Sharia law and the civil law regarding remedies and damages, and what we like to call as contractual damages or actual damages, and which one takes precedent over the other. And last but not least, there is also the loss of profit, which the civil law has now recognized, but it's rarely being applied because of how it's presented or how it's legally formulated into the award. But it's still there, and I think within the advent of time, it will have more precedence to push it forward.
I agree with you. The loss of profit is something that's a very complex way to define and demonstrate, because anyways, burden remains with the claimant. So, showing the future loss, it's quite a challenge. So, of course, I agree with you on that. I'll come to Brendan again. So, which claim tend to be most heavily contested in arbitration? What has been your experience so far?
I think broadly consistent with what Dr. Bassam just outlined. I think there's three key areas. The first one, as I've said before, was there a valid termination? That's usually requires a material breach. So there'll often be a dispute about that because the consequences of wrongfully terminating are very significant for the terminating party. So that will be a key issue. As mentioned, valuing the works at the time of termination can give rise to a whole host of issues. It's not as simple as looking at what's been paid up to that point, because often payments are front loaded, or there's deficiencies in the works, all sorts of other issues. There might be variations that are disputed, so it's not clear exactly what the value of the works are at the point of termination. So that's fertile ground for dispute. Then there's the financial consequences of termination. Sort of example for owners, if they have terminated and they're found to have a valid ground to terminate, they'll often claim all sorts of heads of costs that are related to the termination, such as extra over costs to replacement contractors, additional supervision costs, additional third-party valuation costs, perhaps additional insurance in between the termination the new contractors appointed, and also administration costs with re-tendering the works if that's what the employer chooses to do after terminating the original contractor. So lots of heads of loss there that are disputed over. And then finally, I think you inevitably get all the claims of the project thrown in with a termination claim as well. So you'll get, if the developer had liquidated damages claims, they'll bring those. And conversely, the contractors will try to bring extension of time claims, prolongation claims. So it's really the lot, I think. A termination claim pretty much affects everything. And once parties are involved in an arbitration on that, there'll be any number of claims that are brought by both sides.
Thank you. That's very helpful. I'll come to Dr. Ahmad. So how are like loss of profit and consequential loss claims generally treated in the case in regional context? What is your take on that?
As the Dr. Basim said, that Saudi civil transaction law is recognized the loss of profits and recognize that also the Sharia principles recognize the principles of covering the damages for the innocent party is important part. But we need to know the wrongdoing of the other party is not a source of enrichment for the other party. Here, when we talking about damages and when we talk about losses and when we talk about those, we need to understand here in Saudi Arabia and most of the jurisdictions, the compensation is not punishment. The compensation is to cover the innocent party cost and losses and what he has suffered from the contract. Or if the contract was performed well, how much he was expected to generate from the projects. That's why in Sharia principles and in the Saudi civil transaction law, the losses must be direct, not consequential, or not far, or not there is a huge gap why they are asking or claiming those profits. And as Dr. Basim said, how the loss of profit be presented to the tribunals or to the court. In my view, the compensations, it needs to be well documented or drafted by expert who show a right methodology and give the logic how he calculated, and based on what he calculated and prove the three elements must involve in the responsibility, breach, damages, causal link between those two. And in general, the tribunals or the court will not mind as a principle to award the loss of profit, but it need to be represented by the other party in the right way, and he has an evidence from the expert or from a very solid evidence he can show to the tribunals. To be honest, this is a case by case. Is very difficult to give general principles as we all three of us said about the principles, but it's a case by case. It needs to be well established and identify all the issues, be reasonable, not direct, not really consequential, as you mentioned, or as many people thinks they can do. For example, I give you an example. I do like examples. For example, sometimes claiming overheads as actual losses. Sometimes in many tribunals, they accept it. Other tribunals not accept it, is the way they represent it, for example, when they claim it. loss of profits or loss of opportunity, what I call it more accurate loss of opportunity, if it's supported by expert and the other party was in a serious breach for the contract and was acting in a bad faith. This is the burden points about acting in good faith, not bad faith, also play a role in those things. And this is what I think.
Thank you so much. I will check that line. Wrongdoing cannot be a tool for enrichment. It sums up everything, like how the claims or the should be prepared and how we should approach the termination claim. That should be realistic. That should be genuine, so that it will have more chances of getting successful in front of tribunal. That's well said. So we'll come to next session, which is more about talking about the role of the expert evidence, because that is what I think we have heard from the panelists, that they have been emphasizing on the how the expert is going to prepare the report. A lot of things depend on that. So I'll start with Brendan here. What distinguishes persuasive or I would say like more successful kind of expert report from the one that is more vulnerable under cross examination? If you can come up with some objective lines or the criteria, that will be helpful.
Yes. How long do we have, Dhananjay? Because there are quite a few things to talk about, and it's a favorite topic of mine. I think there are quite a few distinguishing features of a good expert or persuasive expert report that's going to hold up under cross-examination. I think it starts with the instructions, and that's on the onus is on the lawyers there to get that right. I think a good expert report gives an expert broad remit, so the instructions are broad. Often parties and lawyers will want to deliberately keep the instructions narrow in order to elicit a certain response or opinion from the expert that's quite quarantined, being a little bit fearful as to what the expert might say if they were to go beyond those instructions. But tribunals and judges see through that. So it's never a good look if an expert has a very narrow set of instructions. It's always best to give the expert free rein to independently consider a broad range of issues. I think that's point number one. Point number two, I think expert reports, of course, need to be technically correct, which they often are, but they also need to be understandable. I think we're all familiar with the beautifully, densely drafted 800-page report from a delay or quantum expert that might make incredible sense to the expert, but unfortunately, less intelligent people may not be able to understand it. At the end of the day, arbitrators are often, at least in construction disputes, aren't always qualified engineers or experts in delay or quantum matters. So I think the real art is in being able to translate complex ideas and making them very readable and very understandable in a report that the arbitrators are going to understand. I think the third thing is it needs to be balanced. So this goes along with the independence and objective requirement. It's no good for an expert to only consider its own side's evidence. For instance, you'll often see experts who won't even consider the other side's witness statements in the second round of expert reports, maybe because they don't have time or they don't think it's important or they've already formed their opinion. But it's a very bad look if under cross-examination an expert's shown the other side's witness statement, which says something contradictory to what the expert has said. And the expert either doesn't know about it or can't explain or can't quickly adjust their opinion based on that. So I think having a full look at all the evidence that's been submitted is important. And the final point is, there are lots of other points, but the final one I think I'll mention is noting accurately what documents that the expert has received and relied upon. I've had situations before, for instance, in a subcontractor dispute, an expert was given documents relating to the main contract dispute, but didn't disclose that, didn't say that, and that came out in cross-examination. It was very bad for that expert because those documents were quite relevant, and the expert hadn't noted that they'd received them, and so it sort of gave rise to credibility issues for that expert. So yes, important to note carefully exactly what documents you've relied on, and to rely on those documents as well.
Thank you. Thanks a lot. I know it's very challenging to keep it very concise for the purpose of webinar, but then definitely we take away from your discussion that it should be independent expert report. It should be able to present the issues in more simplistic manner, let it be any complex issues with there so that it will be more acceptable to the tribunal. And of course, it should be very well substantiated. That is where the credibility of the expert report carries a higher weight. That's good. Thank you. I will go to Basim. Sir, could you please, at what stage do you think like the expert should get engaged? What can be the best strategy based on your experience as a chair of as an arbitrator as well as the counsel of the party?
I would like to, if you don't mind, do this in two separate parts, and hopefully I can do it very quickly. In listening to my colleague, Mr. Brendan, in Saudi Arabia specifically, the input of instructions to the experts are related very much to their output. Unfortunately, very much. The arbitration panels, arbitrators are sometimes lacking in effort to dig deep into the legal matter, and they give the experts a full range or general instructions. And in many cases, the experts deem themselves able to actually start to analyze and adjudicate matters that are purely legal, and they don't know where the line is between technical and legal, and that is not their fault as much as it's the fault of the arbitrators when they give the instructions. In my opinion, and this we experience this a lot from one side as a lawyer and from the other side as an arbitrator. We get a report. The arbitrator is almost the expert is almost acting as a sole arbitrator, trying to define the whole case, where many things are beyond his control or beyond his, I would say, mandate. This is extremely important. Is to do your homework as an arbitrator, and when you engage the expert, you ask him or her or the institution about matters that are purely technical, and you try to keep them on the straight and narrow. This is something very important in my opinion. When should we bring an expert? There are two main experts, in my opinion, that should be engaged. The experts that are engaged by the tribunal to give an opinion or detailed technical opinion to the tribunal so they can rely on it is one thing. But many huge companies and contractors and disputing parties neglect to engage their own experts beforehand to keep pace with what's going on and with the delays and with the technical difficulties. If you, as an aggrieved party or a party to an arbitration, before going to the tribunal or on the side, bring a very highly reputable expert to help you define the claims and define the technical matters of these claims, that is a huge help for you as a party to the claim, because when you present your report from a very good, highly reputable institution and give it to the appointed expert will find it difficult really to wiggle away from it. He might do some distinctions, some differentiations, some additional matters, but it will be like the overhead guiding light without being forced upon him. This is important, and many, unfortunately, parties try to cut costs by not engaging an expert from day one. That's beyond and beside the expert engaged by the panel, by the way. The other thing is sometimes there are issues with regards to experts because they might be limited. Some of the sites of the construction site, some of the issues in dispute are actually covered. They are no longer available to be quantified. They are underground or they're covered, and therefore the expert must, from the very outset, put this forward and state if he's basing this on documents or documents plus field examination. Last but not least, I believe experts do not come back to the panel for extra explanation. If I was in the panel and an expert comes back to me saying, by the way, you gave me this instruction, but I need more detailed information of what do you mean by this? What exactly do you say by this? This actually makes me feel good as an arbitrator that the expert is going to be focused on what we need rather than simply playing the whole field. I'm sorry if I'm rambling a little bit, but it's one of the very contentious matters in this area.
Thank you. That's quite insightful. Dr. Ahmad, would you like to add on, like, what are the expectations of the tribunal in the region regarding the expert evidence in a complex construction dispute? I see, like, it's a kind of subset of the question what was put to Brendan, but definitely it's a kind of broad question. So you would like to add on, especially from the regional perspective, it will be helpful. I think you're on mute, Dr. Ahmad.
Sorry. Yeah, I thank you. I couldn't agree more with Dr. Basim and Burden about what he have said. But just I would like to highlight small points. It's very important. The dispute management culture in Saudi Arabia and on the GCC. We need to understand that the burden of proof. Each party need to prove his case, and he has, as Dr. Basim said, his own team or expert to shape his or to draft his claims in the proper way. And why we are always encourage the people to have an external expert by them side, because they need to have a fair assessment for their claims in the first place. Because sometimes, for example, they go for prolongations and they put no sense evidence and numbers, and that numbers will increase the arbitration fees and will increase everything, and the volume of the claim, it will be huge. And also sometimes the management couldn't take a right decisions or a reach to the amicable settlement when it's needed or when it's possible. Let's say when it's possible, because they don't have the right information or the proper information to base their decision on. That's why it's very important to each party to have their own well-respected expert who can help them or provide them with the right information, reasonable what they are doing. Because I know many well-respected people, they will not agree with their client just for no sense claims or something. They don't have evidence. And here in Saudi Arabia, in our culture or in the dispute culture, that's always that the tribunals might, or the court, they might need to appoint an expert. In that case, if they have, some people think that expert appointed by the tribunals or by court will help them, or he will do their work, or will write a claim for them, or will collect the evidence for them. They just dump the expert with huge data room and documentation. Many of them is not related to their claims or for other projects. They don't do their due diligence or their homework in the proper way. For that reason, I agree with Dr. Basim Abedin that they need to have their own, and they base their decisions in the dispute and the termination and everything based on the right information, right facts, right things. this is what I think in addition to what well-respected distinguished panel said.
Very, very practical advice. So basically, there are numerous reasons to have the expert on board at early stage. But then very critical reasons, as your just panelists have pointed out. One is especially in Saudi Arabia, if the tribunal appoints the expert, that expert will have a very limited time, and it is unlikely that they will be able to go through all the documentation, substantiation. So it becomes quite challenging. Many times you see the report that the expert will come up very clearly and bluntly that due to lack of documentation, I could not assess this particular claim. So that all these things can be avoided if you have an expert, your party appointed expert in the beginning, or when you see that the things are gonna go southward. That's one. And another one, which is very practical coming from you, sir, Mr. Dr. Ahmad, that there is always a bias. Like everybody has that no, whatever we are claiming, we are going to get that type of thinking is always there. So there is nobody is going to give them a kind of neutral view. And that is very, very much important. That can solve a lot of issues. I mean, you may tend to go towards the negotiation and try and settle the matter, or you will be at least able to strengthen your position, or you can relinquish the matter altogether. So that is also very, very important aspect. Parties thinks that whatever we are claiming, we are going to get that, and everybody will think like on a very positive way. Especially this is a adversarial process where you have to have the criticism also, you have to have the other side also known very well in time. So thank you very much. So what we can do, like just like as a quick question, we can start with Dr. Ahmad. You're already, I can see your face. So how critical is the alignment between delay and quantum assessment in post-termination disputes? Just a very quick opinion on that.
I didn't hear the last bit of the question. What do you say?
Okay, so how critical? So what usually happen, like the delay analysis and quantum analysis is done by different experts, and many times it is observed that they are not in sync, they are not aligned. So how critical it is if you are like counsel or you're an arbitrator, how important critical it is that both the reports should be aligned?
Let's agree on one point. The construction dispute is different than the other many disputes or the commercial disputes. It's vary. As you mentioned, sometimes in some cases they need both expert, quantum, delay. Some firms doing the both of them. In the problem we face in the arbitration, we didn't face the problem because many of the arbitrators, they understand the differences between the two, and also the well-respected firms or like Masons or the others, they make sure that they differentiate between both of those and the documentation needed and the expertise needed. But the problem is in the local court or in somehow just appointing the engineers, and the engineers sometimes in many cases they mixing the roles. They don't have the right expertise in those things. My practical advice to any tribunals or the parties to make sure that they read the right credentials from the expert and they knows exactly and be specific with their request. When they ask the tribunals, they need to specify, as Dr. Basim said, or help the tribunals to write the right scope, the right expertise, the related experience must be highlighted in the hearing report, the tribunal reports. They need help sometimes about this.
Okay, thank you. Brendan, would like to add on this, like if delay quantum, they are not aligned, how things are gonna make it difficult for counsel or the tribunal?
Yeah, I think in a construction case, delay and quantum in particular, as you would noted, Anjay, have to be very aligned. The main role, or one of the main roles of a quantum expert, is to price the delay and disruption claims. So essentially, the quantum expert needs to see the work of the delay expert first before it can finalize its report. So often you'll see the finalized delay report going to the quantum expert a few days before all the reports are due. But that's one in particular. For instance, extension of time claims and prolongation costs. The quantum expert needs to know where in the project the critical delays were in order to be able to price those delays. So yes, that's one situation where I think the two experts need to be very, very closely aligned.
But Sim, I know like you have a lot of things to say, you being a part of like tribunal for so many years, but just any quick advice or any quick suggestion on this, like how you are tribunal as a tribunal, how you look at that, if there is a big difference in the delay and quantum expert reports.
From my own simple experience is that unfortunately the experts sometimes in Saudi Arabia, especially when they are only engineers, they quantify the delay, but they do not itemize it. So it becomes difficult for the other side, the person who is trying to convert the delay into actual amount, to know which part of the project that was done in time, which part was delayed, and which part caused the other part to be delayed. And was it totally the fault of one party, or was it the fault of a third party, or was it the fault of the employer himself? These delicate matters are extremely important for the experts and also for the tribunal to recognize and realize upfront, and give the different respected experts the delicate and precise instructions, because this will inevitably reflect on the fairness of the award and on the actual possibility of the award being appealed on such vague grounds sometimes in the courts of appeal. So this is maybe my 2 cents or 2 pennies worth of addition to what our respected panelists said, Dr. Ahmed and Mr. Brendan.
Thank you so much. Thank you for that advice. So let's come to the cross-examination and tribunal expectation. A lot of our audience are coming from different backgrounds. Some of them are experts, some of them are like claimants, or they have acted as respondents. So, and they may be familiar with this scenario of cross-examination. It's basically a process wherein your testimony, whatever you are saying as an expert report, is being examined by the other side. So we'll come to that part, because we have a panelists who are very distinguished, who have worked in this area. So let's try to get something from them. Dr. Ahmed, I would like to start with you again. Are there any regional nuances in how the tribunal in Middle East especially assess the expert testimony?
I would like to give you my answers regarding to Saudi law, where I am practicing, and some of the regional arbitration I was participated. And as we agreed, or as we know, is that the culture of the dispute in Saudi Arabia now, law of evidence recognize the cross-examination as a part of the evidence in Saudi Arabia. And it's allow that the cross-examination is happening in the court and also in the tribunals in many cases or many occasions. That cross-examinations in our culture wasn't that exist, or wasn't that we wasn't see it in the Saudi Arabia or in the civil law countries like the common law, or in the UK, or in the other side, or the international arbitration like it should. For me, it needs the right people. They need to be trained about the cross-examination process, and they need to know exactly what is to make sure that they are representing the right things, the right opinions, that very accurate, very you direct the question to the right person, not asking someone or the expert something outside his reports. In my view, we see progress in that side in Saudi Arabia in the arbitrations, whether it's locally or regionally, or in the Saudi Arbitration Center as well.
Thank you. Brendan, what are the most common weaknesses exposed during cross-examination? What has been your experience so far? Like, I would say, like, just no-go areas. What are the major critical issues you face while appearing as a counsel?
Yeah, I think it's essentially the reverse of the good points I said that an expert should have in its report. So I think everyone's probably familiar with the term hired gun. So tribunals typically aren't very in favor of experts who are only there to promote their own party's case, and who do not make any attempt at all to appear objective or independent. So I think that's number one. An expert will quickly have problems if they don't appear objective and independent. I think they need to know their report, not only from front to back, from back to front as well, and possibly other angles as well, because typically cross-examination will be rapid fire questioning on the perceived weakest points of that expert's report or reports. And an expert will be taken to very quickly to certain excerpts within their report and be expected to explain those. So if an expert doesn't know their report completely, then they'll probably come into troubles. And that's why lawyers always annoyingly remind experts to read their reports 3, 4, 5 times before going to the actual trial, because it's just so important to know your report in as much detail as possible. I think they're probably the main things that I would say need to be avoided.
Thank you so much. So let's come to the segment where we can speak more about because we wanted to take some more questions. But let's say.
Can I just interject, if you don't mind? Just a quick interjection here for the sake of clarity. It is very important for all our participants to understand, at least from where I come from, the difference between two kinds of experts. There is the expert that is presented by one of the parties, and this is where Brendan said hired gun, and that is usually what is known in the West as an expert testimony or an expert witness. And there, the cross-examination is much more fierce and much more lively. But there is, in Saudi Arabia, mainly the expert is not appointed by either party. He or she is appointed for the sake of helping the panel itself and the arbitration panel to come to certain technical matters. And that kind of expert is not giving his or her report to the different parties. He is giving his or her report to the panel. And it's the panel's right to say, I refuse this report, or I accept it partially. Or it's the panel's right to open the report for cross-examination by the others. So the two different kinds of experts that we're talking about.
Yeah, I think this distinction exists more in Saudi Arabia, especially also here in Oman. So of course, I mean, this is very, very interesting and interesting view on that. Let's come very quickly to because we are of course running out of time. This has been so far very wonderful, wonderful session. So, but let's try and come to the area where we can try and avoid, like the parties who are our audience, how they can avoid. So I will ask Basim, like, can post-termination dispute realistically be resolved through settlement, or are they typically driven to arbitration?
Well, the academic answer to this is that everything can be resolved through settlement. And my opinion as a lawyer, not as an arbitrator, is to push the parties for mediation, amicable settlement before going to actual arbitration. Unfortunately, I would say the fog that surrounds the case because of the lack of documentation, because of the private or self-righteous feeling or thinking that he or she is going to prevail, put them in a mindset that no, we have to go to arbitration, we have to resolve this by an award, and we will get all what we are asking for. Unfortunately, reality very quickly hits when they start submitting their briefs to the panel, and the briefs are lacking in evidence, and the panel asks questions, and then they cannot answer it properly, and they beat around the bush, and this is where reality strikes. But then it's too late. Under Saudi law, under Saudi arbitration law, it is possible to actually delay or stop the arbitration for a while in order to go back to negotiations and then submit a settlement to the arbitration panel, so the arbitration panel can actually document this settlement and initiate the award according to the settlement. It is doable also. The question is it better to settle before or settle during? Always settlement is better if it's a win-win situation. The danger about settlement is when one party is in extremely distressful situation, monetarily or legally, and they have to capitulate to the other party because of monetary issues. So there are many factors in this that could take place, but that's outside the realm of arbitration. It's the realm of the lawyers of the parties.
Thank you so much. Just very quick opinion I would request from Brendan. Can expert evidence meaningfully assist in early settlement discussion? Just to give more unbiased view on the matter and the parties can go into the settlement. Anything on that, Brendan?
Yes, absolutely. So I think the message has come through today to appoint your experts as early as possible. I think it's a realistic or a reality check for the party to hear what someone else thinks from the outside about the strength of their case. So that's helpful. I think also particularly in construction matters, for example, with delay, a party may have, or typically during the project, a party will use a forward or prospective forward-looking time impact analysis type delay analysis. When the project's complete, that's often switched to a retrospective looking back now the project's complete type analysis, and that can completely change the amount of delay a party might be entitled to. So I think it's a good check for a party to know exactly how strong its claim is before it embarks on arbitration proceedings. And then I guess there's the other avenue as well, is that experts might be able to use in a joint way. For example, expert determination, which the parties can decide can be binding or not binding. But it's a helpful way for the parties to jointly appoint someone to perhaps narrow or even solve some of the issues, which again can avoid costly arbitration or litigation.
Thank you so much. Anyways, we are already running out of time, but I would like to take a last question, and I would request Dr. Ahmad with more focus on the mitigation or the curtailment of the losses. So, some valuable insight I'm seeking from your end, Dr. Ahmad. What immediate steps should the parties take following termination to protect their legal or commercial position?
First of all, I think is the first things they need to do is preserve and capture all the project records. Is very important elements they need to start. If there is termination is happening, they need to preserve and capture all the project records, because we see many cases the project records was missing, and some of them give excuses. They seize the site of the project before they kick outside of the project. Some of the employers do that. They not allowing the contractor to get into the site. That's why we always insist on preserve and capture all the project records. And also in my view, the conducting the site review or site condition review and have it in the proper records is very important. And this is how some of the experts can help them in that part. For me, it's very important to assess the dispute resolution strategy in that one, whether they will go with the mediation or start with the mediation, whether they are prepared for the mediation or they have the right information, they have the right records, they have their own assessment in the right way to know exactly where is the room of the agreement between the parties and what is the disputed items. For example, if they have a delay, as Beden said, they have done the delay analysis, or this is delay happened because of the reason outside of their control or beyond their control. This is very important part, to be honest. and engaging with the right people from the legal perspectives and the expert perspective. It's very important part as early as possible.
Thank you so much. That's quite insightful. So we are already running out of time, and we have in fact crossed the timelines. I'll ask if we can take a couple of questions if there are. We already have one question. I mean, it's up to you. Any of the honorable panelists can answer that. What could be a strategic checklist for a checklist to prepare for an arbitration? It's a very vast question, I understand, but any quick opinion or suggestion will be very helpful to our audience. It's one of the questions what we have received. Maybe anyone can answer, like Ranjan, Basim, or Dr. Ahmad.
I'm happy to jump in.
Yeah.
Yeah, I think it goes back to the point of a party. Back to your point about settlement considerations. Typically, what a party would do is have what's called a merits analysis to look at all their claims, look at the potential claims from the other side, the strengths and weaknesses of both. Trying to attach some values to some of those predictions. And that's where you bring in experts as well to give a more independent backing to the merits review. And what that really does is tell a party in commercial terms whether they think or whether it's worthwhile balanced against the cost of arbitration and the likelihood of success, whether it's worthwhile to take their claims further to arbitration or try and settle them before going to arbitration.
Thank you. Due to a shortage of time, we may have to conclude our session here today. So on behalf of Masin, I'm thankful to all the panelists. Mr. Basim Alam, thank you so much. Dr. Ahmad, Mr. Brendan, all of you have been here. You have done an excellent insight you have given that has been very valuable to the audience in general as well as to the expert community. I'm very thankful to the audience for joining us, being patient, and I hope this session would be very beneficial to you and would have added to your knowledge on the termination and the consequences and how it goes into the arbitration. Thank you everyone for joining once again. Thank you.
Thank you very much.
Thank you very much.
Thank you everyone for listening.
It's a pleasure.
Nice to meet you. Thank you. Bye-bye.